welcome on behalf of Ronald Leenes, the head of TILT. And why we organized this panel is because TILT is this year celebrating its 25th anniversary. Not as being TILT with this name, but we started 25 years ago as a center of informatization, law, and administration. And well, we thought that that was actually the starting point of TILT, the origins of our institution. And what we would like to do is reflect upon the research, taking steps of about 5 years, and see what we can learn today from mainly the dissertation research and big grant researches that have taken place in TILT revolving around privacy and data protection. And this was actually almost the starting point of privacy and data protection research at TILT. It was a Dutch study. We already had an act on data protection prior to the directive, the European directive. So the study actually had a look at, well, what can we learn from this act in terms of implementing this European directive, this obligation that came to us in 1995. And this study was conducted, amongst other people, by Corinne Prince, who was the founding mother of our institute, and she would really have loved to be here today, but unfortunately she's on holidays. But she is still an active member of our community and still very intrigued and busy with all types of research that are still in the domain of privacy and data protection. So many other researches in privacy and data protection commenced from there. And in the beginning, we maybe had 1 or 2 researchers in the domain. I think currently at TILT about 20 people are engaged with the topic. So, well, that kind of gives an insight into its incredible development and the many questions it still raises today. So then, looking back for future lessons, what can we learn? Well, we want to find that out today with a lot of people that at one moment in time were involved with PhD or grant research at TILT in the domain of privacy and data protection. Well, Ronald is chairing. I hope he will be later on. And we're very, very pleased and proud that we have Gloria here to be the moderator of our panel. She's not a TILTie, but we've met on many occasions, and she's oftentimes a very interesting and well-informed discussion partner for us at TILT when it comes to these types of issues. So thank you so much for being here in our panel. We will start with Peter Blok, who wrote a dissertation on the concept of privacy, and that dates back until 2002, so it will be interesting to see if there are any changes from there. Then I will have the floor again. I'm sorry, but I was the next in line to defend my PhD, where I had a look at a private law approach to privacy and data protection, mainly data protection. Then we will move to Nadezhda Purtova, who had a property approach to privacy. So let's see how these tie in and what we can learn still today from that perspective. And then Ivan will tell us a lot about a very big project that we had ongoing at TILT under the heading of Professor Bert-Jaap Koops, which is revolving around the typology of privacy. No, I'm telling it wrong. He will inform us about the correct way to frame it, because I'm doing it wrong. But it was a huge project ongoing for 4 or 5 years, and they have a lot of new insights into privacy and data protection. And then Claudia Quelle will take the floor, and she is currently a PhD student, but she will be finishing next year. And she is now looking into a risk-based approach to privacy. So, well, here you already see that many different approaches can be taken to one specific topic, and that it is interesting to see what this will teach us today for future lessons for privacy and data protection, because, well, that's something that I'm sure of. In 25 years from now, we probably will be having another panel like this, and we still need insights on privacy and data protection, looking to the future, but learning from the past. So, I hope you will enjoy this session. We've agreed that we first have brief presentations, and afterwards we have a huge discussion where the floor is open to everyone, so feel free to ask anything then, and Gloria will be as kind to keep time management, so there will definitely be plenty of room for the discussion. So, may I invite Peter as our first presenter of this research.
Thank you very much, Colette. Well done, in particular being a stand-in for Ronald. Ladies and gentlemen, I started my research in 1997, so more than 20 years ago. And the world looked differently then, and particularly if you look at from a privacy and data protection perspective. To start with, there was no such thing as TILT, as Colette already explained, at least not an institution under that name. When I started there, it was called the Centrum voor Recht, Bestuur en Informatisering still, but it is an organization that was founded then. Facebook wasn't there, the GDPR wasn't there, but what was there 20 years ago was confusion on the meaning of the concept of privacy, and that is something that is still valid today, and therefore it may be interesting for you also to hear my presentation on what I did in that research. Because the aim of my research was to clarify the meaning of privacy, and I did so by making a comparison between Dutch and US law, and more in particular Dutch constitutional law, tort law, and data protection law, and US constitutional law, tort law, and data protection law. And to summarize the findings of my research in one sentence, there is a meaning and a core meaning of the concept of privacy, and in the sense that it is protecting the respect for a private sphere. But what we have seen is in the context of data processing, what I would call an inflation of the private sphere, and that has certainly changed the meaning, and that is what I will try to make clear in this presentation as well, because that has a lot of consequences, including that a lot of other concepts, values, and interests are included in the concept of privacy that before were framed under other legal subjects. So the traditional concept of privacy was the idea of the respect for a private sphere. What is important in that respect is, and that is something that sometimes people working in the field of data protection and information privacy tend to forget, is that that concept of, and that right, protected against all kinds of interferences. Publication of information and use of information is one kind of interference, surveillance is, but also more physical interferences such as hinder or trespassing in the home could be considered a violation of private life. And even legislation was considered an interference with private life. For instance, think about the cases on prohibitions of homosexuality. That was an issue under the concept of private life. So in that sense, it was a broad concept in that it offered protection against various forms of interference. The other side of the coin is that the scope of the right of privacy was rather restricted, in particularly if you compare it to what the way it's considered today, in the sense that it was a restricted private sphere. There was an idea of a distinction between public and private. Some aspects of a person's life were considered private, others were considered public, and the right of privacy only protected the private life aspects. What were those? Well, if you look at the text of the European Convention of Human Rights, you can see the main components: the home, the family, and correspondence were considered private in those days. But other aspects of a person's life were not considered private in the sense that they should be protected by a right to respect for private life. Think, for instance, of speeches by politicians in parliament, public gatherings or demonstrations in public places, meetings of religious associations in church, for instance. those were not covered by the right to respect for a private sphere. That, of course, didn't mean that there was no protection, but those activities may be covered by other rights than the right to respect for a private sphere, such as freedom of speech or freedom of religion, but not the right to privacy. Now, if you move to the area of data privacy or data protection, what we have seen is what I would call an inflation of the private sphere. And as I said, the traditional idea is that the right to privacy protects the private parts of a person, but not the public parts. And what we have seen in the context of data privacy is an inflation of what was considered a private in the sense, and the result actually is that to date every aspect of a person's life is considered to be private in the sense of delineating the scope of the right to privacy. So there is no public-private distinction as it used to apply. Also very public aspects of a person's life, like the ones I mentioned, the speeches in parliament or activities in public places are considered today an aspect that is protected by the right to data privacy, and even public, it is even the case that public activities deserve more protection. For instance, as we know, data relating to religion or political activities are considered special data deserving additional types of protection. The consequence of enlarging that scope of protection is that there is a shift of focus from, on the one hand, the delineating the scope of the right of protection to the criteria for limiting those rights. Or so, if you look at the European Convention of Human Rights, Article 8, it usually the interference with privacy in the sense of paragraph 1 is assumed, and then the focus is on whether that interference is justified. And so the debate often is there a sufficient legal basis? Is the legitimate for, is there the interest in the purpose of the data processing? Is that legitimate? And more in particular, where almost any debate on data processing is about, is the necessity of the data processing. So that is the focus of the debate today, and that is actually, if you look at it, also those are the main principles of that underlie data protection law and laws like the GDPR. That approach is criticized both by data controllers who argue that means that the concept of privacy has become too big, in the sense that it also encompasses rather trivial data processing operations, and on the other hand, the privacy advocates argue that there is no protection anymore because what data protection law does is merely regulating interferences instead of preventing them. But the main thing is that there is still the idea of the respect for a private life, but now we have a private life encompassing any aspect of a person's life. That means that there has been a considerable shift in the meaning of the concept of privacy in the area of data processing, and that you could argue, and that it would be better to separate the two and to adopt a different approach to data processing. And actually, that is exactly what has happened after my research, I must say. As you know, in the EU Charter now, we have two rights which are relevant in this respect. We have Article 7, the right to respect for a private life, and on the other hand, a separate right for data protection. And a similar thing we can see if you look at the Data Protection Directive and the GDPR. Interestingly, if you look at the first article of the Data Protection Directive, there the main object of the directive was formulated as protecting the right to privacy, But if you look at it at the GDPR, this has been deleted, and instead it is now in particular protecting the personal data. So to end, if you look at it from a legal perspective, at the current legislative frame is quite in line with what the findings of my research, but I'm aware that will probably not be the result of reading my dissertation. Thank you very much.
Not yet. Colette. Not yet. I will have to. Which one is it?
This one. The one you have.
This one.
Yeah.
Can you hear me like this? Yes. So just that it's normally it's not allowed to have so many panelists from the same institution. This is why we are going to be very strict with them. So you are presumably not all from Tilburg. So you can ask questions also. It's also legal. It's an illegal panel because I'm not supposed to be on the program so many times. So I can fall down on the program, but don't say this to me.
Okay. Yes, I can start. Okay, well, a private law approach to privacy, that was my topic of my dissertation back in the day. And well, for this we go back to the year 2000. And well, the picture that you see on my book, the boat there, actually was taken in 2000. I was sitting on a beach in Kenya, and I was thinking, what the hell did I got myself into? Why am I doing a PhD research? Why am I wasting 4 years of my life on a topic, privacy and data protection? And I felt like a very lonely person sitting in a boat, rowing on an ocean, and there was no shore in sight, so what was I doing? What was I thinking? But in retrospect, it's about lessons learned. I think that the most important lesson that I learned is, yes, privacy and data protection are still amazing topics to research, even almost 20 years later. And I use the word discuss on my slide, and I do it on purpose because, well, I have been rather busy with the Master Law and Technology program and not really engaged with fundamental research, so I didn't really dare to use the words research here. So yes, I still like to discuss the topic privacy and data protection. The question that I posed in my dissertation was, is it possible and not prima facie undesirable to regulate the protection of informational privacy in the Dutch Civil Code? And I took a perspective from EU law. What does EU law require us to do in terms of implementing a directive? And from Dutch civil law, well, what's the aim and structure of our civil code, and would data protection fit into this structure, and would it fit the aim of the Dutch civil code? But also from Dutch administrative law. What would it mean for Dutch administrative law if we would change a public law into a private law approach to privacy? And well, the second lesson I learned thinking back on my research was, okay, it's completely irrelevant now. We have no obligation to implement, we have the GDPR, it's a regulation. So, well, bad luck. Or maybe more like this, phew, I am in a lot of luck, because if I had to reflect upon my research today, being it still relevant, I had to be on par with what is happening in European law, what is happening in civil law, what is happening in administrative law in the Netherlands, and I simply do not know. It has been 15 years, so I was quite fortunate not having to reflect upon that question and simply telling you, well, it became irrelevant, we have the GDPR now, and we do not have to implement. The beginning of my dissertation came from a question, why copy a predecessor if there is so much criticism? The research already referred to, Sun, Moon, Star, Zon, Maan, Ster, had quite some criticism regarding the structure and the type of law that we had in the Netherlands. A public lawfulness act telling us what to do and not to do. So there were questions raised within this research, shouldn't we have chosen another perspective? And that is, at least in part, still relevant. as there is still quite some criticism regarding privacy and data protection regulations. And another thing that was important to my dissertation research were the insights that I had gotten from Peter Blok's dissertation. I mean, that's how it works in a research institute. You look at each other, you learn from each other, and you get intrigued by someone else's work. And, well, the relationship between privacy and data protection, well, it still interests me today. And it still raises question, as data protection does not always have to coincide with privacy. And what then does that mean for these two rights? So lesson 3, we are not there yet. There is still a lot of criticism, we still have a lot of questions, and for me that has to do with decisions that we have made in the past. So we must look back to learn from that. Because I think that quite some issues and questions come from the fact that we have two pillars in one legal instrument. We have the protection of individuals with regard to the processing of personal data, and we have the free movement of such data. And to me, that's on the one hand a fundamental human rights approach, while on the other hand, more like a commodity type of approach. And how can we align these two in one simple instrument, or a very complex instrument? So lesson 4, data protection as a fundamental human right does not make things easier, or at least that is my perspective. Because I see a discrepancy between theory and practice. I mean, there are a lot of data brokers, and that is a private law approach to privacy and not a fundamental human rights approach to privacy. So, if we consider the data subject in the center, which is oftentimes the claim that is being made in research, should there not be more leeway for individuals to trade their own personal data? And a very warm welcome from Ronald Leenes, who made it after all. Thank you for being here. So, if we consider the data subject in the center, should there not be more leeway for individuals to trade their own personal data? Or do they need paternalistic government protection because they are unable to protect themselves? We all know this quote, if you are not paying, you are the product. But what I tend to wonder these days is, but aren't you otherwise paying double or even triple? And this came to mind when I saw this advertising. Are we paying to become the product these days? We are paying to send our DNA to some kind of private company to get a product or service out of it. Doesn't that mean that we pay with our data and we pay to get the product? And, well, we're kind of paying with everything and not getting a revenue. And this is something that I found interesting. It's not doesn't come from me, but I heard Marleen Sticker and Bart Jacobs discussing whether or not we should treat these sensitive types of data just like organs, where there is a strict prohibition that we are not allowed to trade them because they become so influential to our lives that we need way stronger protection than mere privacy and data protection. So that kind of steers completely away from the commodity approach, or you could say puts a halt to the commodity approach that you see happening in practice. Didn't research this, but I find it intriguing and I think it is something important for future lessons. That's also why we are looking back. So, profit is being made of our data anyways. So, do data subjects not evenly profit as they perceive data as a right and not as a product? And this, of course, is my bridge to the research of Ms. Nadezhda Purtova, because what about a property law approach to privacy then? And that's the theme that she has addressed. But before I give her the floor, I want to share with you the main lesson, and that's lesson 5. And that is that I want to thank TILT for creating such a vibrant environment where we are able to freely debate and discuss these issues, not having to agree with each other, but creating an environment where we actually reflect from different perspectives on how to make the world a better place in this respect. And I'm also very curious to witness the next 25 years in privacy and data protection development, and I hope that it will be as being part of TILT. The final thing that I want to share with you is, as we are celebrating our 25th anniversary, we have an entire year of dedicated events with a lot of guest speakers from all over the world, not only privacy and data protection, IP, competition law, what have you. And the program is shared at this website, and you are all more than welcome to join us whenever you like. Thank you. Nadezhda.
Hello, everyone, and thank you for being here. And I will start where Colette left off. So, is it a good idea to perhaps introduce property rights in personal data? That was the research question I had for my PhD research in 2006. And then when I started, so in early 2000, this idea of property rights in personal data was really sort of on top of research agenda. On the slide, you see just a small snapshot of the literature that came out in early 2000. So there was a bunch of American authors who were discussing this issue, and their response was basically the argument of propertization of personal data there was considered sort of as a big patch to address the shortcomings of the US information privacy law, because there was no universal or universally applicable right to information privacy and control over personal data. There were also European scholars who joined the debate, but they addressed the subject mostly basically as a way to address the phenomenon of commodification of personal data that started in late 90s to early 2000. What unified those scholars coming from different jurisdictions, different disciplines was basically, the conceptual dissonance. Because what I noticed in that literature was that the authors who were making arguments for or against property in personal data came, as I said, from different jurisdictions, different disciplines, different normative sort of frameworks. And so there was no agreement as to what they meant by property rights in personal data, and hence what the introduction of property rights would entail. So when I started, I had 3 departing points. Well, they didn't emerge right when I started. It took a while. But sort of my perspective was the perspective of protection of an individual. So would property rights, if introduced, do a better job in protecting an individual than the existing data protection law, back then the directive? Then what to be protected was informational self-determination, understood as individual control over access and use of one's personal data. So propertization for me was not a way to facilitate market exchange in personal data. And then the third departing point was that I meant to sort of use as an anchor point the meaning of property rights based on the comparative European property law. So there is no European property law because property, well, strictly speaking, formally is taken out of the competence of the European Union, but then there is a body of research which is increasingly growing, which sort of finds the common denominators across the various European jurisdictions as to what property rights in what property rights would mean. And so the problem, as I saw it then, was twofold. Well, basically the problem was that under the old directive, it was difficult to invoke control rights over personal data and enforce control. And that was due to the fact that the flow of personal data was very complex. So there was a variety of multiple actors involved in processing personal data, and it was unclear for the data subject or for the supervisory authorities what the relationships between, basically who the involved actors were, what the relationships between them were, if data was processed, and how sort of a piece of data made it from point A to point B. So what resulted was a problem of lack of transparency of data processing and a lack of accountability for data processing. So it was difficult to be aware that data was processed and how, and it was also difficult to identify who the responsible controller was, to whom you could address your sort of grievances. So the conclusion I arrived at was that if our aim was to ensure the individual control over personal data, then property rights in personal data do make sense and would perhaps even do a better job than the 1995 Data Protection Directive. So how so? This is based on two characteristics of property rights in European law. The first one is that property rights are characterized by one common denominator, which is so-called erga omnes effect, which is translated as basically the effect against the rest of the world. Property rights are exclusive rights. They give you a right to exclude everybody else from, in case of personal data, from your personal data. So this was, let's say, suppose you would have property rights in personal data, then it would give you the right to exclude from your personal data, and so such a right would be easier to invoke and enforce without the need, well, at least because there would be no need to establish a responsible controller. Anybody who would process your personal data would be sort of under an obligation to respect your property right and stay away unless permitted. Another implication of defining property rights like that via erga omnes effect is that property rights do not necessarily imply market alienability or free tradability of personal data and free sort of waiver of data protection rights. This is not what, in my view, property rights are about. Then the next defining feature of property rights is that if the only sort of characteristic of property right that matters is not alienability but erga omnes effect, there exist multiple kinds of property rights of various scopes. So not only full ownership, and then when you transfer the ownership, you also transfer automatically all the rights attached to the subject of property, to the object of property rights, but you could also create sort of smaller property rights, sort of data licenses, if you will, which when you sort of transfer a license, you do not transfer the full body of control rights over personal data, and that would be consistent with the European human rights approach to privacy and personal data. So it would also help sort of install accountability and transparency when it comes to controlling data flows, because that would create sort of a trail of licenses that would sort of keep a paper sort of trail of under what, on what grounds data is processed, or who processes data for what purposes and such. So that was my theory back then, and the conclusion, well, so the conclusion was yes, property rights were a good idea. At the same time, the word property was, I considered this as just a label. So ultimately what matters is not whether or not you attach a label of property to something, but what scope of rights you want to grant to the individuals over personal data. Does it mean?
No.
Okay, thank you. So still, do the conclusions I made back then hold in 2019? Well, for sure, like one thing is that the rhetoric of propertization of personal data has been revived. There were policy initiatives where personal data would be considered as currency or counter-performance. Some interpret some innovations in the GDPR, such as data portability, as the step towards property rights in personal data, which I don't think is the case. There is a lot of ownership talk in the context of sort of data platforms, living labs, smart cities, and such. So there is definitely relevance to keep talking about property rights in personal data. Also, basically, the problem that I meant to resolve back then still partially remains. Data flows are still complex. The variety of actors involved in data processing are still multiple. But if, so data processing is complex and perhaps even more so than in early 2000. At the same time, the GDPR already took some steps sort of towards achieving the scope of rights in personal data as I saw them back in 2010. So it has become, or one would like to think so, it has become easier to invoke data protection rights, at least for two reasons. First, because of the broad interpretation of the notion of controller by the European Court of Justice, and by introduction of the principle of accountability in Article 5 of the GDPR. So it's a little bit similar. The principle of accountability, which requires the controller to be able to demonstrate compliance with data protection law, is a little bit similar to this idea of the license trail, or paper trail of basically justifying legitimacy of processing personal data. And yet, the GDPR, contrary to some arguments, does not create a right to exclude from one's personal data. Processing is allowed by default. And then finally, what is more important is that the departing, basically one of the core departing points that I had for my dissertation, the individual control as the rationale for property rights has been extensively challenged. Do we want an individual to control personal data if basically if the effect of processing one's personal data also sort of spreads downstream and affects others? And basically the doubts as to individual control are illustrated by consent debate, whether or not an individual is able to basically exercise meaningful control over data due to the limitations of his knowledge about what happens to data and the consequences and such. So my conclusion is that the argument does need to be revisited or updated, and yet property thinking helps us ask the right questions about data, the nature of data, and the rights we think should be introduced in data. And then I will just, the questions that I had for general discussions were, well, can and should personal data be owned? Or at least what should be subject to the right to exclude, and owned by whom, if the answer is positive? Well, thank you.
Okay, my name is Ivan Škorvanek. Actually, the name before I repaired it said _Korvanek, but that's not correct. I will briefly talk about the project that I'm working in as a PhD researcher, and that's a project funded by the Dutch Organization for Scientific Research, and it's led by Professor Bert-Jaap Koops. And it's a project that has been running for 5 years now, and there has been, if I count correct, around 9 or 10 researchers, not at the same time, but throughout the year. So it's a bit difficult to explain in 8 minutes what it is all about. So I'll just give a very high-level overview of the project. And what we focus on is privacy protection, but by doing comparative constitutional and criminal law. So we don't really deal with the personal data aspect. And although we did write a paper on the typology of privacy, we had a panel about it here at this conference 2 years ago, and Gloria was one of the panelists, and she explained very well why it's not a good idea to do typologies of privacy. So that's not something I wish to talk about today. And rather, I will talk about the main aim of at least the part of the project that I'm participating in, that's finding new boundary marking concepts for private life protection, and mainly in the law enforcement context. So I will first just explain what I mean by boundary marking concepts, and these are concepts that help distinguish between major and minor private life intrusions. The traditional boundary marking concept in criminal law is the concept of home, where things inside the home are protected more than outside. So the boundary marking helps determine what sort of procedural safeguards should be put in place. So, for instance, if police wants to monitor someone on a public street, they generally don't need special authorization. Lower suspicion is required. However, if they want to monitor someone inside their home, they generally need to get the judicial order. They can only do it for a list of serious crimes, etc. Okay. So the home is the place-based, the distinction between private and public spaces has traditionally been the main boundary marking in the criminal procedure. However, and the underlying assumption is that most private activities take place at home, and at the same time, there is also sort of an assumption that in the public space we don't need so much protection because we can sort of rely on the anonymity. But both of these assumptions are perhaps not true anymore, as the home evaporates in the sense that, in one sense, we cannot just protect from physical intrusions because it's way much easier to see inside with all sorts of technologies, and at the same time people carry their smartphones, and that contains more private information often than could be found in a thorough search of their home. And at the same time in public space, which is becoming more relevant for privacy because we carry all sorts of digital items with us, we are also under much more surveillance nowadays. So this is why we think that this traditional boundary marking does not really work anymore, and I will later explain a little bit with some concrete examples. I skipped the whole research, and I just come up with with the three approaches to boundary marking that we have identified. And one is the container, so that's typically body, the home, also communications channels. Those are the old boundary marking concepts. And the new ones that we see emerging are computer as a new sort of container, or a smartphone, or more metaphorical concepts such as digital home or informatic home. Then the other type or another approach to boundary marking is content. So we don't just protect the container and everything inside, but we focus on specific content that we want to protect. So for example, personal data, but that's just not very useful in criminal law context because it's too broad. So you can distinguish between different sensitivity of data. For example, the German idea of a core of privacy, which needs to be strongly protected, or writings. And then we see new boundary marking concept in this content approach, such as the mosaic theory. I will talk a little bit about it later. The systematicness criterion in a Dutch criminal procedure. And then the third one, which is rather a recent addition to our thinking, and it still needs to be developed, so please don't ask me about it, is the flows approach, such as the professional privilege, and the new sort of idea emerging is the information fiduciaries. And how we go about it, we look at different applications, different cases, or different things that the law enforcement is doing, and we look how the traditional boundary markers apply, and whether the jurisdictions, the courts, the doctrine comes up with different new ones because the old ones are not sufficient. So one paper that we have written is on location tracking by the police, and this is generally something that is done in public places. It doesn't target information that's considered very sensitive in itself, just location data. So based on the traditional boundary markers, it's not considered very intrusive. However, we see with new technologies that allow really more convenient ways for the police with very little effort. For example, GPS tracking location of the phone with stealthy pings, IMSI catchers, etc. And long term, and it can actually become very intrusive because it can map social contacts, daily habits. It could even reveal sensitive medical information based on, let's say, what health providers you visit, etc. So we see that in several jurisdictions, these new types of boundary markers come up, such as the mosaic theory in the US, the systematicness requirement, which is not that new, but it's being developed as well in the Netherlands, or the prohibition of creating comprehensive personality profiles in Germany. And what they have in common is the idea that the accumulation of data, which in itself does not have to be very intrusive, can create an intrusive picture of someone's private life. So the idea of a mosaic, the mosaic metaphor, if you look at this picture, you can hardly say what you're looking at. And unless you're like a real expert in Soviet art, you probably wouldn't know that you're looking at Lenin, because we just have a very small frame of the picture. And that's the idea, that if you collect more and more, and if you know how to put it well together, you can create a very intrusive picture of someone's life. Of course, the drawback of this theory, that if we compare it to the container approach of the home, that's very clear-cut. It's quite easy to put in practice. A policeman knows, okay, now I'm entering a home, I need to ask for a warrant, but to decide when a picture is intrusive enough to reach this higher threshold, that's a bit more difficult to determine. So then you need to create new proxies, for example, how long you observe, etc. So it's conceptually attractive, but it's much more difficult to put in practice. Do I have a bit more time?
1 minute.
Okay, so I will just briefly talk about one more case, police hacking. That's a paper we just submitting today. And here also police hacking into private computers. The traditional boundary markers such as home or communications, they are not able to capture what is really protection worthy in computers, because it doesn't matter really whether it's located inside the home or if it's somewhere else. The police often doesn't even know where it is located. So what we see emerging in various jurisdictions is new sort of container approaches where they recognize computers themselves as protection worthy. So you could say it's sort of a new home in the law. For example, the German basic computer right, the Italian concept of informatic home. You can see some quotes here, but I will just stop here, I think. Thank you very much.
Last speaker, for your questions, because it's 8 minutes.
It's the black
This
one.
one, the sixth one.
It's the black
Yes.
one. Yeah, yeah.
Okay. Don't touch too much there, because it's very noisy.
Okay, I'm just setting a timer. All right, good. So my name is Claudia Quelle. I'm a PhD researcher at Tilt as well. And I'd like to start by saying that it's really a privilege, and it's really quite humbling as well to be here with all these speakers, because in a way, these are the shoulders on which I think current research is built, right? The proverbial shoulders that we stand on as we conduct new research. And just hearing it all again, it's so obvious to me at least, that I've picked on themes and aspects in my own research, even though my topic is quite different as well. So my supervisor, Ronald Leenes, fortunately was able to make it. Apparently my morning was not the most hectic of all, because you clearly trumped it. And my other supervisor, Bert van Roermond, is a professor in legal philosophy at Tilburg. And you know that Ronald is our head of department. Okay, so that's introductions. The topic of my research is the risk-based approach, but I'm going to focus today about what that means, in my opinion, for the role of data subjects, because I think that's a nice continuation with what we've discussed before. And it is also a part of my dissertation. So I'm going to have this bold statement be sort of the catch for my whole presentation, and that's data protection does not revolve around data subjects. They're not the center of the universe, not as individuals, that is, right? And first I'll say a bit about the risk-based approach, because that's sort of the inspiration as to how I came there. But I think the generality of data protection law lies deeper, goes further than the risk-based approach alone. So from there, I think we can conclude on the role of the individual data subject under the GDPR, that is. And if I have time, I might consider a counter-argument, but I might have to let that sit for a while. So the risk-based approach. I know it's kind of controversial because lobby was involved in creating the risk-based approach. But in my opinion, it is embedded in a number of articles in the GDPR, and it also has more protective elements. Because what it means, in my opinion, in my own words, is that the controller must implement the GDPR such that the rights and freedoms of data subjects are proportionally protected. Now that's my own words, because what the GDPR actually says is that controllers have to take into account the risks. And that's why we call it a risk-based approach. But I would say that it's really about the rights and freedoms there. And what this does is it does two things. It says, well, we all know situations in which data protection law is being ridiculed because it's so burdensome and these are just harmless processing operations. Why do we have to tick all these boxes? That's where the risk-based approach kicks in as it was intended by the lobby. By saying, well, if it's really not risky at all, you don't have to do so much to be compliant. I would say that's the case under the GDPR. But what I'm more interested in, actually, is the second aspect of the risk-based approach, and that is saying, okay, there are also situations in which data protection law maybe doesn't provide that substantive protection that we want, and we actually want controllers to do more to address new, social and technological issues, for example, discrimination in the context of automated decision-making. Then I would say the risk-based approach brings in such considerations through the principles of data protection and requires controllers to really articulate this sort of compliance 2.0. But what I find most interesting here is that we wanted to place this responsibility on controllers so as to unburden supervisory authorities and data subjects as well. So that's the evolution there. We want controllers to be responsible for the rights and freedoms of data subjects. And we can see that that responsibility is for the processing as a whole. And this goes back already to the principles of data protection. Article 5 reads, processing shall be fair. The controller has to make sure that processing is, predictable, purpose limitation, etc. That the purpose is legitimate. I mean, that has, in first instance, very little to do with an individual data subject, right? I would say these are obligations of general law. And I wouldn't necessarily say they're public law or private law, because think about labor law, food safety, product safety, administrative law, they all have these general obligations. And that characterization is what I'm interested in. And the risk-based approach only emphasizes that generality by referring to data subjects as a plurality, like the group privacy debate has reminded us. We're concerned with the rights and freedoms of data subjects, plural, right? So where does that leave the individual data subject then? Well, I do think they have a very important role to play. With respect to the processing, I think the data subject has two different roles, in fact. We see first that they are a beneficiary of these obligations of general law, and we see, and can enforce these rights as well, and we see second, that they also have a measure of control. So, talking about being an enforcer of general obligations, what I'm thinking about here is, for example, the right to access, the right to erase unlawfully obtained data, the right to rectify inaccurate data. What we see here is that the controller is simply in violation of data protection law, and the data subject can come in and say, hang on, I want to do something about it. Then, of course, they can also issue a complaint to the supervisory authority who's responsible for enforcement on their behalf, right? And we see that the data subject is the beneficiary, especially through the right to receive compensation. Because if data protection laws are breached and you suffer damage, you can be compensated for that as well. I think that's something else from saying that the data subject is in control over whether the processing is permissible or is not permissible. That we see with consent and with, for example, the right to object. Because if you consent, you say, well, I want to legitimize a processing operation that otherwise maybe wouldn't have been legitimate. And with the right to object, you delegitimize a processing operation that otherwise would have been permissible, right? But note that both these rights or competences are very limited in scope. I mean, how often do we have to remind everyone that consent is not the only legal ground, right? And the right to object is also quite limited. So this is a small rule, but an important rule. Now, what I'm thinking about right now in my research, here we have a visualization of it. So I would say the controller is responsible towards all the data subjects, and then you can come in as an individual, sort of the second act of the story, and be like, well, I would like to see things a bit differently, right? And so that role of the individual, I'm really talking about data protection law here. I'm not talking about the role of individuals in democracy in general. This is data protection law. The individual comes as the second act. Now, I can imagine that we would say that the data subject does figure at the center of data protection in other ways. Especially data portability has got me thinking about this, but also this idea that as data subjects we're in control of how we are portrayed with accuracy. So I am definitely open to counter arguments, but looking at the principles of data protection, I think the permissibility of the processing is the key consideration, and in that respect, the role of the data subject is quite limited. So thank you, that was it. Thank you for having me.
Hello, we will open in. Does it work now? Yes, yes. So I will open the room for questions in 1 minute. Just to say one thing before also I give the floor to Ronald. I was saying before, I was trying to explain, this is a non-compliant panel because there are a series of rules in CPDP. One of the rules is that we don't have everybody from the same organization. Another rule is that we have different stakeholders, so not everybody is a researcher. And nevertheless, I think it's a great panel. It has been, for me, a great experience. I think it should be an imposed exercise in the future, that you created a new concept, which is summarize your own research group in 1 hour. It is a very, very difficult exercise, like 25 years of great research in 1 hour with this quite logical presentation. I think it's a very good thing. So I don't know, I was thinking already about the name of this concept. It's like a rewind, fast forward, your, I don't know, whatever. So I don't know, that's my suggestion for the future, but Ronald?
Yeah, so apologies for being late. I mean, that was the 2 centimeters of snow in the Netherlands, and I really got up early this morning, but delays, and then I made it half an hour late. So I don't know what happened in the first half hour. I gathered that Colette said something about what I was intending to say at the start. But let me not eat up time here. So I think, and we haven't, so Gloria and I haven't synchronized really before the panel, but the idea was to give the audience as much room as we can. So I think I'd like to hand the floor to the audience for questions. And do we have a microphone? Okay, so Charles Raap on the 3rd row, or 2nd row, depending on how you count empty rows. Shoot. Thank you.
Don't make it complicated, Ronald. It's the 3rd row. This is not so much a question as if you will allow me to contribute to your 25th anniversary celebrations, because I go back quite a long time in my connection with Tilburg, even before Tilt. And I want to give, as briefly as I can, some impressions about why it is important and why it was important that TILT got established and that this area of research into privacy, data protection, developed in Tilburg. Back in the, and from my perception, in the 1990s, there was a lot of research going on at Tilburg in what was the previous incarnation, that is to say, the informatization in public administration, which had other people in it besides the sort of TILT complement of people. And there was a great emphasis there upon e-government and on the development of efficient and effective services to the citizen through new means of public administration. There was very little interest in privacy at that time, and I think this is largely, if I may say so, my perception was that because there were very big grants from various government ministries to promote the efficiency and effectiveness of public services, and it kind of crowded out any consideration, but hey, what about privacy, and what about protecting the citizen whose data would be used in e-government? So informatization was the name of the game, and then privacy and privacy law and other kinds of privacy considerations came along in the late 1990s, and I was privileged to be a visiting fellow or whatever for solid 2 months in 1999, and then again as a visiting professor in Tilburg in 2007. And it seemed to me that the development of these areas of research, which are manifested very well on the panel today, made Tilt and Tilburg really put it on the map as one of the leading places to do this kind of stuff in Europe and also internationally. But I think that the political and governmental importance of having that, it wasn't simply a kind of scholar's dream to work on privacy, but because it seemed to me to be a little bit of a pushback to widen the conception about what happens to personal data. It's not only a tool for administrative efficiency and effectiveness, but also for human rights and citizen rights. So congratulations to all of you.
If I may briefly comment on that, Charles, I think you're right. At the beginning, it was indeed so the combination of the legal scholars and the public administration scholars, and the focus was pretty much aimed indeed at e-government. But on the other hand, the starting point, as denoted by Colette, is a sun, star, or moon, was a 500-page evaluation of the data protection regulation at the time. So that was a significant piece of work, and later when we separated from the public administration people, we could fully go on privacy and data protection, and here we are.
Other questions? Yes.
Thank you. That was very interesting. When I was listening to you, I was wondering what is the aim of data protection, because the first one was separating data protection from privacy, then it was control might not be the aim of data protection, at least not in practice, because it's not what's happening, and then it's also not about the individual. So what is data protection about, and what kind of world does a perfect and effective data protection law want to create? What do we want to achieve with data protection law?
Wow, that is quite a question. Let me try to give the start of an answer. In my view, the starting point is that is the idea that information is power, and you need to apply the principles of the rule of law to power, and that's basically what data protection law does. It applies the main principles that we have established in the context of the rule of law, such as that there must be a legal basis, that there must be transparency, and so forth, and apply them to data processing, and thereby creating legitimizing the use of the information power.
Yeah, I also find this a very tricky question, and I'm inclined to agree that it's about the rule of law, but at the same time, and we have these substantive provisions as well, such as fairness. So in my opinion, it's basically, if we do it, it has to be done right. If we don't do it, we're protecting our privacy. So it's sort of like drawing the boundary between, privacy and permissible intervention, which you might refer to in terms of justice, right? But what I'm struggling with in my research is that boundary is drawn also in a procedural way. So it's not just about providing these standards and then abiding by them, which I would associate the rule of law with, but it's also about sort of distributing decisional competence between these actors, including data subjects, but now increasingly also controllers, and previously, especially supervisory authorities through prior checking. So it's sort of making sure that the decision between what is public and what is private in this type of context, which is very different, of course, from the law enforcement context, but that decision, that boundary, that is drawn in a decentralized manner rather than in a top-down manner.
Because Colette, you brought in this idea of commodity, which I think, if I will watch the panel in slow motion to see where they got it wrong at some point, and I think that this question of why is data protection about a commodity?
Well, I'm not sure if data protection is about a commodity, but as I said, what I witness in practice is that it is used as a commodity, and that brings into the equation, or it raises the question then, if we are using it as a commodity, why aren't we treating it in law as a commodity, and what does that then mean for a distinction of, on the one hand, trying to treat it as a fundamental human right, and on the other hand also trying to do justice on the second pillar of the legal framework, having this free flow of information, which sometimes I feel is a little bit overlooked when it becomes too complex in law to be able to deal with data no more. So for me, the purpose of data protection would be, if we look back at how we constructed it, to align these two. But yeah, as I already explained to you in my presentation, I do not have the answer how to correctly do it, because there seems to be such a huge discrepancy between the two that I sometimes wonder if it is correct to join them in one instrument. Maybe these are two separate things. But, well, that's an area of research I would have to engage in more deeply to be able to give the proper answer. But that's the aspect that I'm struggling with, the two legs, you could say, of one right that we are trying to combine in one instrument. And I think if you look in practice, we are failing at.
Yes?
There are more than two legs there.
I think microphone.
First of all, thank you for the presentations. They're all brilliant. Although as the panel went, I realized that I know most of your writing. It was each of this presentation gave some additional insight, which was really nice. Going back to following the discussion, maybe there are more than two legs there, because we just somehow rely on this preamble that there is a balance between the individual right and the free flow of information. But first, what is free flow of information? Second is that if you think about the public interest, or the individual interest and the public interest, we may conclude that the public interest is not only in sharing, but also in preserving privacy, preserving data. Maybe public interest is on both sides of the equation. Maybe the balance is much more nuanced and complicated than just free flow and individual rights. So maybe there is a direction of the research actually to go deeper into those concepts of privacy and data protection and figure out maybe it should be more substantive than procedural. Maybe it should be more concrete what kind of interest or will, depends of the way we see the law, we protect, and redefine something, shuffle those dice. I mean, roll the dice again. Thank you very much.
Yes.
Does it work? Yeah. So thank you for the comment. I fully agree with you. What does that mean, free flow of information? In fact, these two sort of legs, they migrated to the GDPR from the directive, and the directive was the common market instrument. It was there to harmonize the legislation of the member states, to prevent the member states from installing the boundaries for data flow across the borders because of the differences in the rules. And somehow from this free flow of information has morphed into more sharing of information for economic welfare, sort of. And nobody in the middle discussed basically the meaning of it or implications of it. So this is one. And also I fully join your second comment that, well, let's put it this way. I think that data protection law at the moment has really, it for a while has been experiencing an identity crisis. The GDPR doesn't know itself what it is for. It is for everything that has to do with personal data. And let's say, if we're speaking about boundaries here, the major boundary, let's say, in the data protection law is the notion of personal data, what constitutes personal data, and when personal data is processed, the GDPR applies. So when we look at the meaning of personal data, what should trigger the protection, basically, any impact on individuals associated with processing of information, computerized processing of information, is covered by the GDPR. And nowadays, everything is mediated by automated processing of information. So you can construe let's say, from just departing from this boundary concept of personal data, you can construe the data protection law as the law that basically has a potential to address any consequence of automated data processing, including even distributive justice considerations. Where I think there are at least 2 projects at Tilt now of 5 years that are busy with exactly what data protection law is for or supposed to be for.
Thanks. Yeah, I wanted to tie into the argument that maybe we should have more substantive protection. And I think given that data protection law has so wide a scope, if we also really formulate top-down what is and is not permissible with respect to all this processing of personal data, then we would have quite a thick, governmental, rule setting there, and it would really be quite invasive, I think. And I think, so on the one hand, we need to have the rule of law safeguard, we need to make sure that everything is just and that privacy as a public good is protected. And at the same time, I think we see a reluctancy to really put those decisions in the hands of one entity, and we really want to distribute it, not just in terms of the traditional, checks and balances that we have at the state level, but also by involving controllers and data subjects. I mean, there's a reason that supervisory authorities didn't want to do prior checking anymore. I mean, they couldn't do it, but also I think we have to ask whether it would have been desirable if we had still had that sort of system. So that's just a doubt I have regarding the proceduralism and the substantive nature of data protection, given its encompassing nature. Right?
Last question might come. Yes.
So just echoing people, thank you very much for a very interesting historic overview of your work. Looking at how this goes forward, there's other areas of legal concepts that we can draw some similarities with. I think copyright is an area which answers some of what Colette was saying, because it has this boundary between freedom of speech, but also the property rights. There's also some stuff we could think of from the financial area, where the idea of a financial fiduciary, so that instead of looking at somebody who holds your data as the owner of that data, just as we look at a bank as being the holder of your money, but not the owner of your money, but they have rights to do certain things with it, we should be maybe looking at holders of data as fiduciaries with certain rights to do things with the data they hold, but not as the owner per se, but as the holder, with a fiduciary responsibility towards the data subject. So I think there are other areas of law we can bring some interesting comparisons in to try and give us some better tools to work out some of these still tricky muddles we have in what is privacy and what is data protection.
Thank you. I think even we didn't you were talking with this now, because I can feel some pressure. But so Ronald, do you want to say something about final word?
Yeah, no, okay, I want to go back a little bit. So I found the question that was asked at the beginning, what is data protection for? An excellent question. And I think when Peter started with, in his view, it is about checking the powers of controllers. And I think that is actually a fair rendering of what also, in my view, data protection should be about. And then the discussion was more or less about where we see the frictions at the moment of the GDPR, for instance, in not satisfactory covering all sorts of things. And I see lots of regulators coming in, so I may get myself in trouble here, but there are all sorts of discussions, and also bringing and looking at other ways of dealing with the sort of the effects of data processing. So we've had propertization. You mentioned copyright. I mean, at the moment we had have a discussion in Tilt in whether or not the powers of the big five, let's say, should be checked in some form, and then suddenly competition law enters the stage and things. So I think ultimately there is this issue of checking the powers of data controllers, and whether or not, so that I think should be the, and if you bring in rights such as privacy and other things into the data protection domain, things become difficult. And maybe I would see it as a sort of a venture for Tilt in the next 25 years, is to come up with a proper way of handling the powers of data controllers, and maybe we should call that another, not data protection but something else, but I think we need that somehow.
Thank you very much. This is speaker integrity protection. We don't want to be here attacked by people. So thank you very much. Thank you to the speakers, and see you in another panel. Thank you.